Hello, this is Rex Crandell, and the topic for today is working with family members that are approaching or have dementia or incapacity. And we're talking about not so much the medical side, but the financial side and managing assets. First, we need to determine who's going to be managing the property of the incapacitated person. There are several tools in the estate planning toolbox to handle the person with dementia, one of which is a durable power of attorney for asset management. It's durable because it lasts beyond someone having a diagnosis of dementia, and it allows another person, an agent, to manage finances for the incapacitated person. Some of the disadvantages of a durable power of attorney for financial management is the agent under that document needs to be extremely honest, because it could turn out that a dishonest person would take money away from the incapacitated person and commit elder financial abuse. Another document that is used if someone goes towards dementia, and that is a living trust. If someone created their own living trust and now they're becoming incapacitated, when that happens, they're removed as trustee. Another important document that the person should have in place is an advanced health care directive, because an incapacitated person cannot communicate clearly with medical personnel in terms of what type of care and treatment they need. What should you do if someone that you love can't or will not sign a durable power of attorney? In first scenario, let's say it's too late. The person never signed a durable power of attorney, and now they've got full-blown dementia. Well, the law in California allows the family members to take the person to court to get a conservatorship to protect their interest. A person is appointed as a conservator, and there's a lot of paperwork and court supervision over the entire time the person's alive with incapacity. But it's the only way to handle the situation, getting authority to manage assets, if the incapacitated person never took the time to get their papers in order. There is one saving grace sometimes in a conservatorship, and that is for people with a long-term marriage and all their assets are in community property. The competent spouse has complete right and authority to manage the assets for both spouses. So in that case, if a person became incapacitated, they might be able to avoid a conservatorship of the estate, which is finances. And it still may not stop the other type of conservatorship, which is conservator of the person. But an advanced healthcare directive goes a long way in help reducing the need for a conservator of the person, which means medical, non-financial. Okay, let's say the person is competent, but they refuse to sign a durable power of attorney. Well, it's a problem. They don't want to acknowledge the fact. Frequently, people are stubborn. They don't want to give up any rights. And one alternative, if someone is reticent or refuses to sign a durable power of attorney, is to create a voluntary conservatorship. It's a lot less time consuming and costly if the proposed conservatee consents, and there doesn't have to be a doctor's determination of incapacity. It's a preventative document in case, especially if the person's mental abilities are deteriorating. A voluntary conservatorship is a good option. And the other type, if the person won't get it, eventually they'll probably have to get a conservatorship of the estate. And at this point, it's not so much about age or dementia, it's about anyone over 18 with the ability to manage their assets. At some point, they may have a car accident, head injury, and all of a sudden, now they have to have their assets managed. And a voluntary conservatorship is lower cost if it ends up being a contested conservatorship, which means that the proposed conservatee or other family members object to the legal procedure, then it becomes quite more costly in the court process. The best idea is to take the situation and actively handle the situation with all family members participating, getting their estate plan in order for various types of things that might happen in the future. When someone is declining in mental ability, and you can see that over a period of time, it's time to get into action. You might want to consult with a geriatric care manager to help determine what might be needed in the future. Also start the discussion with the proposed conservatee. Gather important papers, get copies and information relating to Social Security, bank accounts, investment accounts, safe deposit boxes, get all the financial and asset management information that you can, including passwords to internet accounts, online storage. And that way, if the person deteriorates into full-blown dementia, that you're able to manage the assets. Review the plans, the durable power of attorney, advanced healthcare directive, the trust over a period of time to see if situations have changed. It's also a good idea to discuss funeral and burial arrangements, cremation with the person, so that it takes the anxiety away from the other family members when that event takes place. So some of the things you look for as key indicators that someone might be approaching incapacity is having trouble with money, forgetting to pay bills, paying the wrong amount, getting confused about what the bills are. One thing you can do to help the person is set up automatic bill pay accounts with the bank, and also have a trusted family member start taking over and supervising the finances of the person, and so that you've got the system in order if the person does get full-blown dementia. Another thing that's very important is to protect the vulnerable person from scams and frauds. I know when my mother was over 90 years old, we used to get phone calls all the time with every kind of scam you could think of. And it was very concerning that that kind of thing goes on. So the other thing you want to try to establish is a plan, and also start planning for long-term care costs, whether that's a long-term care insurance policy or other ways that you might have to pay for long-term care. If the person needs to go into a nursing home, skilled nursing facility, it might cost $6,000-7,000 a month for housing. Another thing that is a possibility is if the person denies that they're mentally slipping and they're having problems, and you know that that's actually happening and they're a risk to themselves and others in driving, you can contact the Department of Motor Vehicles, and they will, once they have a notification that a person is suffering potentially case of dementia, they will require the person to come in for an evaluation and get medical opinions. What DMV looks for is three things: consciousness, are they able to respond normally to the environment, cognitive processing, do they have the ability to remember what the destination of what they're trying to do is, and strengthen coordination? So if somebody's getting close to dementia, their stimulus response and their muscle movements may not be that effective for their own personal safety. So the DMV is there to help if that is of necessity or benefit to you. So overall, in summation, the best way to plan for dementia or incapacitated persons, which can happen and probably will happen to all of us, is to get an estate plan in place. Have a living trust, especially with real estate. Have a will, a pour-over will that only speaks of death. It's not really useful in incapacity. Have a durable power of attorney for asset management, appointing an agent, an alternate agent, and an other alternate agent. For every appointment of a person in your estate plan, have 3 alternates. And an advanced healthcare directive, and also assignments of personal property. So with these documents in order, the process is not going to be pleasant, but it'll be a lot easier than it would be had it been without those documents. And with the documents, it'll cost the family less to administer the situation. If you have any questions, give our office a call. We're happy to answer questions about estate planning, tax, and other issues.